Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I am your host Urvashi Chauhan, here to bring you daily developments, landmark judgments and significant rulings from the world of law. We begin with the headlines and after that we will delve into the full details. Noting mismatch between statements of the Delhi Lieutenant Governor and DDA Vice Chairman in Delhi Ridge tree felling case, the Supreme Court has now sought new affidavits. The Supreme Court has issued notice on a plea against the High Court order to register FIRs on statements of Malayalam cinema actors to Justice Hema committee. The top court has refused to entertain an NGO's plea alleging violation of the order staying demolitions. In the NCP dispute, the Supreme Court has told Ajit Pawar to declare that clock symbol is Sub-Judice in the posters for Maharashtra elections. The Supreme Court has granted interim protection to a journalist in Uttar Pradesh's police's FIR over her article on caste discrimination. The Supreme Court Bar Association Executive Committee has objected to changing Supreme Court emblem and the Lady Justice statue without consulting the bar members. The top court has said that it will stop the practice of recording appearance of advocates who did not argue or appear. The Apex Court has refused to entertain a plea for inquiry into reasons for High Court judge's recusal. Starting with an update on the Delhi Ridge illegal tree felling matter. The Supreme Court today observed that there was a discrepancy between the statements of the chairperson of Delhi Development Authority, that is the LG VK Saxena, and vice chairman of DDA regarding the date on which LG was informed about the illegal felling of trees in the Delhi's Ridge forest. A bench comprising CJI Chandrachud and Justices JB Pardiwala and Manoj Mishra was hearing the contempt case initiated against DDA Vice Chairman for the felling of trees in Delhi's Ridge without obtaining the mandatory permission from the Supreme Court. On 16 September, the court had asked the chairperson to file a personal affidavit on various aspects. The court noted that as per the affidavit filed by him, the information about illegal tree felling was conveyed to him on 10th June by the vice chairperson. However, as per another letter issued by the vice chairperson, the information about the tree felling was conveyed to the LG on 12th April. Taking note of this mismatch, the court has asked both the LG and the then DDA vice chairman to file affidavits on this discrepancy. The matter will now be heard on 5th November. Stay tuned. The Supreme Court has today issued notice on a petition challenging Kerala High Court's order in the matter concerning Justice Hema Committee report. The High Court had directed the police to register FIRs on statements made by women actors to the Justice Hema Committee regarding the abuses faced by them in the Malayalam cinema industry. The High Court, after reading the entire report, had stated that the statements revealed commission of cognizable offences and directed the Special Investigation Team to register FIRs after conducting preliminary inquiry. An SLP was filed by film producer Sajiman Pirayal challenging this direction of the High Court. The SLP contends that when the victims themselves were disinclined to lodge FIRs, the High Court could not have issued such a blanket direction. The statements made by the victims to the committee 6 years ago cannot be regarded as information as per the Bharatiya Nagrik Suraksha Sanhita when they themselves are disinclined to initiate criminal proceedings and have not asserted the statements later. The SLP further states that the SIT itself has stated before the High Court that none of the witnesses who gave statements before the committee were ready to cooperate and give a statement to the police. The bench of Justices Vikram Nath and P.V. Varale issued notice today and posted the matter to 19th November. In the next update, the top court today refused to entertain a PIL initiated by the National Federation of Indian Women, alleging contempt by certain state authorities of the court's interim order staying demolitions without permission. Last month, the Supreme Court passed an interim order to the effect that no demolition shall take place in the country without its permission, except when there is encroachment on public roads, footpaths, railway lines, or water bodies. The Council for the Federation argued that since 1st October, that is when the court extended its stay on demolition actions without prior permission, 3 incidents had taken place in Uttar Pradesh's Kanpur, Uttarakhand's Haridwar and Rajasthan's Jaipur in violation of the court's order. Taking the court through reports covering the incidents, the petitioner highlighted that the Uttar Pradesh incident related to the case where a restaurant was demolished after allegations were levelled against it regarding mixing non-vegetarian food with vegetarian food. But the bench of Justices B.R. Gavai, Prashant Kumar Mishra and K.V. Vishwanathan declined to entertain the plea, noting that it was filed by a party which is not directly or indirectly affected by the alleged acts. The Supreme Court today told NCP leader Ajit Pawar that the Nationalist Congress Party should use the clock symbol for the upcoming Maharashtra Assembly elections with a disclaimer that its use is a matter of contest in court and is subject to the final outcome of the petition filed by Sharad Pawar. You already know that following a rift between the Sharad Pawar and the Ajit Pawar factions of the NCP, the Election Commission of India recognized the Ajit Pawar as the official NCP based on its legislative majority and allotted the original United NCP's clock symbol to it. The Sharad Pawar group appealed to the Supreme Court challenging the ECI decision. In March this year, the court permitted Ajit Pawar faction to use the symbol with certain conditions. The court had directed NCP to include a disclaimer in all the campaign materials that use of the clock symbol is sub-judice. Today, a bench of Justices Suryakant, Dipankar Datta and Ujjal Bhuya was dealing with Sharad Pawar's application alleging violation of the conditions by the Ajit Pawar group. The court today issued notice and directed Ajit Pawar to file an undertaking to the effect that the previous orders will be followed for the state assembly elections as well. The bench orally warned that it would initiate suo motu contempt if its orders were violated. And with this, the matter was posted to 6th November now. In the next update, the top court today granted interim protection to journalist Mamta Tripathi, who was booked over the articles written by her. The articles alleged caste discrimination in the administration of the Uttar Pradesh government. After this, 4 FIRs were stated to have been registered against her. Her counsel, senior advocate Siddharth Dave, argued that it is a case of pure harassment, as whenever journalists even tweet something, be it regarding district magistrates using red light on their vehicles or caste issues between Thakurs and Brahmins, FIRs are registered against them. When Justice Gavai asked as to why the petitioner has approached the Supreme Court directly, the senior counsel replied that another journalist, Abhishek Upadhyay, had also recently moved the Supreme Court directly for quashing of an FIR registered by the UP police over a story written by him, and the top court had granted him interim protection. Dave also said that the same is being done as there has been a violation of their fundamental rights. A bench of Justices B.R. Gavai, Prashant Kumar Mishra and K.V. Vishwanathan issued notice to the Uttar Pradesh government today and granted interim protection to Tripathi in relation to the 6 articles written by her. On 1st September, a new emblem and the flag of Supreme Court were unveiled by the President of India to commemorate 75th year of the Supreme Court. The Lady Statue of Justice, which is placed inside the Judges' Library, also had certain changes. Traditionally, the statue wore a blindfold to signify that justice would be administered impartially without regard to the status of the person. The new statue of Lady Justice is not blindfolded and carries the book of Constitution of India instead of a sword. In this regard, the Executive Committee of the Supreme Court Bar Association has passed a resolution objecting to the unilateral changes made to the emblem and the statue of Lady Justice without consulting the members of the bar. The association has also objected to the proposal to build a museum in the former Judges' Library. It had earlier demanded a library and a cafe-cum-lounge for the members of the bar. The resolution states that the bar members are equal stakeholders in the administration of justice, but these changes, when proposed, were never brought to their attention. As per the resolution, all 21 members of the executive committee have unanimously opposed the proposed museum in the high security zone and demanded for a library and a cafe cum lounge. In another update, the Supreme Court refused to mark presence of an advocate in the order, saying that she did not argue or appear, though the senior advocate who argued the matter was engaged by her. The counsel, a young woman, tried to reason why she wanted her appearance to be marked before a bench of Justices Bela M. Trivedi and Satish Chandra Sharma. She said that she engaged a senior advocate and it was a common practice for the appearance to be marked. But the bench refused with an intention to discontinue this practice of marking names of counsels who do not argue. Previously, while delivering judgment in the fake SLP case, the bench had observed that advocates on record can mark the appearance of only those advocates who are authorized to appear and argue the case on a particular day of the hearing. Previously, a bench of Justices J.K. Maheshwari and Rajesh Bindal had ordered that online presence of only those advocates will be marked in the order who were either appearing or assisting during the hearing. And lastly, the top court has refused to entertain a petition seeking an inquiry into recusal of Justice M. Nagprasanna of the Karnataka High Court after reserving an order in a case, observing that the petition cast aspersions on the judge. The petition was filed after Justice M. Nagprasanna recused himself from a matter after reserving orders. The plea before the High Court had sought registration of FIR against the wife and son of a state's Lokayukt and investigate allegations of corruption in Karnataka judiciary. While the court acknowledged the petitioner's grievance about the judge recusing after reserving the order, it questioned the prayer of ordering an inquiry into the circumstance of the recusal. The court also objected to the petition, claiming that Lokayukt was in a position to influence the judiciary. The bench objected to the manner of filing the petition, stating that it suggested oblique motives. Justice Oak pointed out that the petition included detailed allegations against various individuals which were unnecessary in a plea seeking guidelines on judicial recusal, as the submissions should have been confined to principles. The bench of Justices Abhay S. Oak, Ehsanuddin Amanullah and Augustine George Massey granted liberty to the petitioner to withdraw this petition and file a fresh one restricting the prayer to seeking guidelines on recusal of judges. For more details on the cases that I mentioned, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Please do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.